Previously, we've discussed how legal means can be used to increase business respect for human rights, hold companies accountable for human rights abuses that they are involved in, and provide a law-based means for victims to seek redress and justice. Now we turn to non-judicial means of achieving those objectives. Looking beyond the law courts, are there other ways to hold companies accountable for human rights abuses they are involved with? What non-legal accountability mechanisms appeal to you? Why? And perhaps a further question to contemplate as we go through this topic, from a victim's perspective, which do you think is preferred, legal or non-legal mechanisms for seeking remedy and redress? Under the UN Guiding Principles, the utility of non-legal mechanisms to achieve corporate respect for human rights is acknowledged. Indeed, just like a company is encouraged to integrate into their processes human rights risk assessment and due diligence, so too a company is called upon to establish a robust, meaningful grievance mechanism, a non-legal pathway for victims of alleged corporate human rights abuses to be able to approach and express that grievance to the company itself. The company then, in theory, would act in good faith to address and respond to that grievance in the spirit of respecting human rights. There are other non-legal mechanisms too, through which victims can seek justice. Remember that third pillar of the Protect, Respect, Remedy framework, remedy. Perhaps most prominent amongst these is called the OECD National Contact Point. That's a bit of a mouthful. The OECD, the Organisation for Economic Cooperation and Development. It's an intergovernmental economic development organisation which has 38 member countries, including Australia. Its mission to sustain and promote global trade and economic activity. Part of the way the OECD does this is by establishing guidelines for multinational enterprises, which now include guidelines on respecting human rights. What makes the OECD guidelines distinct from the UN Guiding Principles is that there is an enforcement mechanism, albeit a non-legal one. Each member country of the OECD has to establish a national contact point, an entity or a person that will hear complaints against a company by human rights abuse victims. The National Contact Point, or the NCP in Australia, has very few powers to enforce its decisions, but that's not really the point. Instead, the NCP investigates the allegations, and if it deems worthwhile, will even bring the parties, the victims and the company together to discuss, negotiate and mediate a resolution to the complaint. While there's no way for the NCP to rule or enforce its ruling, it's free, and in practical terms doesn't cost anywhere near what it costs to launch a civil human rights litigation against a company. Something to ponder. Two other non-judicial mechanisms that I'd like to flag are boycotts and shareholder actions. Let's start with the latter. Remember Milton Friedman's famous declaration decades ago that a company's sole responsibility to society is to make a profit for its shareholders, its owners? Okay, but what happens when those shareholders want something other than profit? Perhaps some shareholders want principles with their profit. Now you may scoff at this idea, and yes, I agree, generally speaking, the majority of shareholders, company owners, in the majority of companies out there are keen on maximising their profits. Yet, there is a minority that are making waves when it comes to business and human rights. Shareholders challenging Qantas's role in the deportation of refugees from Australia. Shareholders challenging BHP's commitment to combating climate change. These are but two shareholder campaigns to urge and pressure these companies to disclose and change their activities impacting human rights, to improve their human rights records. Finally, I wanted to draw your attention to your role in achieving greater corporate respect for human rights. That's right, your role. Right now, today. Yes, you will one day be a titan of industry and a successful lawyer, and I absolutely want you to recall this course when that happens. Drop me a hollow mail when you do. But no, right now, today, you also have a role to play in encouraging business respect for human rights. Boycotts, consumer boycotts, are a prominent public and powerful means of encouraging and pressuring companies to respect human rights. There are consumer boycott campaigns around a number of specific human rights issues. Let me give you just 2 historical and 2 contemporary examples. Historically, Nike faced a boycott in the 1990s due to horrendous working conditions in the Asian factories producing their famous shoes with their swoosh. South African companies also faced a 1980s boycott over that country's apartheid regime. Today, there is a call for boycott of certain products sourced from the Xinjiang province in China due to allegations of widespread human rights abuses by authorities and the complicity of companies there against the local Uyghur Muslim population. Finally, there is the BDS campaign, the pro-Palestinian boycott, divestment, sanctions campaign against Israeli products. Patently, these 2 contemporary boycott campaigns I've just referred to highlight the politically sensitive nature of these campaigns. They also bring into sharp relief a few observations. Consumers really do have power to influence companies. And human rights abuses and how to respond to them are inexorably intertwined and bound up with political and ideological considerations too. Many adherents to these boycott campaigns are motivated by politics and ideology. Is this a good thing? A bad thing? Is this politicized nature of human rights boycotts avoidable? Or perhaps this actually has a deeper lesson for us about the difficulties of pursuing corporate respect for human rights in toto. After all, if human rights are universal, surely all companies should respect all human rights all the time?